Yes.
In your office, that's what you're saying, right? That is cited as a finding of non-compliance in the next financial audit.
Right.
So what exactly does that mean, that they're non-compliant? I mean, is there any ramification for it?
A non-compliance citation can be, if it relates to an internal control or a qualitative matter, it can actually result in a modified opinion. Because there's no direct correlation between the financial operation of a government and compliance with public records, I don't imagine that that would happen here. So the result is an official independent agency has publicly said, you're not following the law on this. What we do know is that, although I don't think it's become an issue in this particular set of audits, what we do know is that in other instances, when we make a finding, it sometimes becomes an issue at the next general election. An opponent will say, you know, the person that's in there isn't following the law, the auditor state says so, and when I'm in there, things are going to change. You know, trust me when I tell you that no politician wants that. So we're hoping that the light of these findings will actually goad public officials into doing the right thing and following the law.
And when you, in those scenarios that you painted a few minutes ago where you showed up and then they turned over the records,
Right.
by doing that, did they fall into the compliant category at that moment?
Well, we're showing them as initially non-compliant. That's what the initially means.
What kind of weight does a audit finding have in court if I went to the Supreme Court for the mandamus action, you know, and the damages that you can get? I mean, is that?
Great question. Audit findings generally have a presumption of validity. There has never been a case directly on point where we have a non-financial finding that would be there. So I imagine it would be argued about, but my position is that our office's work carries the presumption of validity under the existing case law.
Now, you were talking about how this might,
He's standing up anyway.
looking at the radio. You were talking about how this might be a campaign, that if it didn't measure up, the audit didn't measure up. But, you know, in two of these three cases, the OPERS and the ODA, these are agencies. So there's not someone that voters can hold accountable in those cases. So, I mean, where's the teeth in this? It doesn't just, wouldn't they just say, oh, okay, we're in non-compliance, big deal, go back to work.
Well, if somebody takes a non-compliance finding that cavalierly, I don't have the authority and don't want the authority to run the government. There comes a point where if you give the auditor authority to enforce the auditor's own compliance, they're no longer independent. They've become the management. They've become the super dictator, the Donald Trump, if you will, of state government. And you know, that's not the proper role of an auditor. Now, I hope with regards to the board that there would be some concern on the part of the board members, and they'd be asking management, what is this all about? And actually, this goes to something that Randy was grumping about a little bit before the rest of you came in. Attorney-client privilege is not, there was a lawyer in the room. Actually, Buzz Trafford tried to make this argument in the Columbus school case, and a court shot him down and said, no, that's not, just because you were in the room doesn't mean the executive session is okay and that this is all privileged stuff. So things that are attorney-client privileged are things that go directly to work product. In other words, the lawyer created some work product, legal research or investigatory work product from interviews, or it goes to the advice that the attorney gave. Is not a fact of what that the attorney was in there. Frankly, one of the frustrations I've had with our first year here is it's difficult to determine whether an attorney-client privilege is properly asserted or not. And I've been working with legal staff in our office to try to develop some processes where we can get at the facts without disturbing the privileged advice to determine whether there's facts to support the privilege. It's kind of a conundrum because sometimes the facts point to the issues upon which advice was being sought. But on the other hand, we may be headed for, we have a piece of work not related to public records where there's privilege being sought that we may end up having to see whether we can get a court review. And again, a new area that we're not really into. But I'm frankly sick of people asserting attorney-client privilege with little or no basis. It is not as broad as the entire horizon, and it doesn't include anything a lawyer does.
Have you filed a legal action on that?
Haven't. Not
You're asking for an in-camera review to determine if it's being properly asserted. Is that what you're
That
saying?
would kind of be the nature of the action. Now, whether we have standing, what the legal standards are, it's a little bit of uncharted territory.
In any of these cases, after you've taken a position, have these cases ended up in court? And do you stand the risk of becoming a party in that lawsuit, being called as a witness based on the findings that you've had?
We would be a witness, not a party.
Okay.
And to the best of my knowledge, none of these has gone to court.
Dave, do you know in the ODA one, the person who's seeking records concerning individuals, animals confiscated from Mr. Kenny Heftrick, was Mr. Heftrick the one who filed that request?
Do you know who?
Okay. Dave, at one point, the legislature tried to kill this program. And you were a little upset. Vica didn't have it, WB, at the time. And there was talk in the legislature maybe we can get a ombudsman or a separate office to handle this. Have you heard of any discussions of anything like that in the legislature?
I think there's still some discussion about it, and frankly, I'm glad to step aside if there's a proper mechanism to resolve this. The reason we did this, folks, is because right now, if you get stonewalled as a citizen on a public records request, the only thing you can do is go get a lawyer and go to court. And if you're not independently wealthy and have plenty of time to burn, you're out of luck. So, if the legislature develops a non-litigious process that's simple and is open to the average Joe who's just trying to find out what his government is up to, that's great. But in the absence of that kind of a process, I think this program gives an opportunity.
In all of these cases, was the request made by the taxpayer? Can a local government come to you in hopes of resolving an issue where a taxpayer has made a complaint, they'd like to have somebody come down on their side?
Okay, well, the way the flow chart works is they have to start with mediation. So if it's local government, they have to go to the Attorney General's mediation program before we will look at it. So if it's susceptible of a resolution, then presumably it would happen over at the AG's office. Now, the exception to that, which I could see Randy was just about to say, well, what if it's a state agency? Because the Attorney General is conflicted out on that. We would receive those in the first instance. But that pretty much is what these initially non-compliant cases are. They decide that they're not going to fight about it and give the records up.
But it doesn't matter who the person is that brings the complaint, whether it's the agency or the taxpayer. Either side can ask
We've never
for it.
had an agency bring one.
But if one did? asked you to look at it, a state agency?
Would we, if we were asked? I'd have to think about it, but I don't know why we wouldn't. But here's the thing. This exists because of the power inequity. The government is big. They have taxpayer-funded lawyers. They have the records, and they're not going to give them up. Why would they come to the auditor and say, take a look at what we're doing? It's the little guy, it's the taxpayer who can't afford to go out and hire his own lawyer that this is designed to level the playing field for.
How long has this process taken for these first requests from when someone submits it to your office to when you report it on?
The answer is, it's like my underwear, it depends. It does depend on the nature of the request. We have a rule that if it's more than, is it 8 hours? If it's going to require more than 5 hours of staff time, then we're not going to get involved with it because it's probably going to be more complex than should be resolved in this kind of a process. And remember, there are instances where there are genuine competing interests, where it's a complicated thing, and it's not immediately clear how the law is applied to this situation. That's why we have courts. We're not trying to supplant the courts, where the courts ought to actually be the ones to make the decision.
Did you reject any because they were going to take more than 5 hours?
Yes. I don't know how many, do you?
I think for the 5 hour rule, it was just one.
Would that have happened in Jobs Ohio or related to it in any way?
Have we had anything about Jobs in Ohio?
No, no.